define what is in the scope and stick with it. Yes, that's important. List what is, oh, this is more important than what is in the scope. Please define what is also out of the scope. Because what happens when you don't speak about things which are out of scope, what happens? You assume it. Not only you means your client, your organization, maybe the vendor, that it is within the scope of this, and that is where the war of law begins. Yeah, so don't do that. Things which are not included in what services you're giving or what you're asking for, make it very clear and put it at the end that this, however, this is the scope of work and this is what is not included. It is absolutely okay to say that. It is not like, oh, if the header goes scope of work, you cannot put what is out of scope. You can certainly put it and make it very clear for the world at large. Whoever reads the document gets it clearly. Does that make sense? Yeah. Define how out of scope request will be handled. Yes. So that is why you will see liners that anything that then what is mentioned above would be attracting additional cost. So when you get this line, this means that whatever is mentioned here is only supposed to be delivered, is the only service that they're going to give you, service, good or whatever. But if it is not mentioned here and you are asking for certain more services, right, under that agreement, please note that it's not a part of that agreement and we're going to make additional charges, cost, or whatever is required. Even if it requires a separate agreement, it may be required to be drafted. And it happens that there are times when I am sitting there, they have not told me, now the marketing and the vendor has decided that, okay, I'm going to take more services from you. Then what do? At times we have to start with a new agreement. Usually we don't do a new agreement. What we do is we do an addendum, we do those exchange of emails and call them a part of the agreement. Yeah, you can see all these kind of annexures. This is very, very important because while the business goes on executing a particular agreement, there can be demand in the world of technology. Now see, AI has come up, right? So a lot of businesses require different kind of AI to be used, right? They might ask you that, hey, can you implement this AI tool into my system so that, I can generate this kind of reports, I can see these kind of analysis, I can see this kind of strategy around it. So when you do all of that, it is calling for a change. So are you going to change the entire agreement? No. That is why your master service agreement is also coming into place. If you have a master service, if from one project, you can jump to the next project, or you can say it is in addition to the first ongoing project. You're saving yourself from those big 30-pager agreements, but just making one more annexure to that main agreement. That is why SOWs, addendums, exhibits, schedules, these are very important. They appear to be the smallest in the agreement, but they make a hell lot of difference. Yeah. All right, let's move ahead. And now review and approval. Very important. This, whenever I read these slides, it takes me back to the time when I was doing the website for my company. And actually, we had a hard time with our website developer. It's okay. You just learn a lot. Thank God to those hard times. But yes, I remember about all of these steps. It is not like, you're writing review and approval on paper and signing it. It is actually, they bring the system before you. They show you the feel, the look, and they tell you how this is going to appear here, there, everything. And then you can, make a lot of changes. You are reviewing it, you are approving it. If you don't like it, you tell them, no, I don't want this thing. This needs to be changed. This needs to be removed. Whatever changes I'm making, it falls under this column of review and approval. Are you getting it? I am sure that I have a very strong feeling that the way I'm telling you, you can actually see how it's going to work for you, right? You might send a first draft to the client and not hear back for 6 months. This is very true. It says assign time for the client to review and provide feedback. That is where the role of MSA is coming into. That is where the role of timelines are coming into. That is why we are saying have a specific time bound goes by. When you send it to the client, you have put it on the agreement that, hey, you got to revert back in 2 weeks. If you don't, we are assuming it that you've accepted it and we're going to take it to the next step. And this also gives us the right to claim the money for the first part of work that we've done, right? It cannot, if you don't put in all these goals, it is from your vendor side, then your vendor is going to be in a loss. And so also it makes the client proactive. Set a mutually decided number of review cycles, right? It cannot be review and approval, review and rejection, review and approval and rejection, right? You have to say that we'll maximum under this agreement, there are going to be 3 reviewals. Either you approve, and if it is more than that, then it is extra chargeable. There will be a cost for it. Approval windows, similarly, just for review, similarly for approvals. That in these many days, you got to approve it or reject it. Projects can go dormant, who can potentially put in a fee for restarting. Very, very important. If you are the vendor side advocate, please let them know that, hey, if you don't complete this project in this month, or if you don't respond at all, and if it becomes dormant after a time, we have the right to ask you for a restart. You did one part and then they got busy and then they said, hey, sorry, we forgot. Let's please start it all again. You have all the right to say as a vendor that, okay, I'm ready to restart, but for restarting, this would be my fee. Because for you, restarting is not restarting. It is actually starting from the scratch again, from the vendor's point, right? Because he will have to go and check everything that he might have done some 6 months back, right? Let's move ahead. Ownership. Now see, this is the part where copyrights come into, okay? Because everything is based on source codes. This is the part where you also copyright your website. Because once it is fully done, you can ask your developer to give you the source codes and you can go and do a copyright. This is where this ownership tussle begins. That who is going to be the owner? Because the source codes are being made by the web developer, and trust me, if you're not an engineer, you're not going to understand any portion of it. Unless you know the language, right? So the web developer really can have a say that, hey, I've created it. But what is the rule here? The rule is work for hire. What is work for hire? Do a little research of your own. I'm giving you the gist, but please read it. In the long term, it's going to be very useful for you, not only from the angle of a website development agreement. Any time when there is a copyright issue, you will be very happy if you read about this, what I'm telling you today. It is about reading work for hire. Work for hire means, today I have hired you to give me a particular service and I'm paying you for that, right? Then I have the ownership, right? That is what work for hire is. Sorry, 1 second. So that is how it is supposed to be. So when there is a website development agreement, please know the person who's hired you for the job is supposed to own that website. Yeah. So you cannot say, I have built in the UI UX, I should own it. Unless in a very rare situation, that is the case between these two parties, it can be not a big deal, because it may be two companies that are coming together. One is a big website developer and he has decided that I'm going to retain those rights. The other party might agree, right? But it can be a rare case scenario. Usually it is the person who hires for the job. I hope that is making sense. Customers want to own their website and often contribute to the website development project. Developers want to own the tools they use to develop website. Website often includes third-party material, many of which are subject to third-party licensing. Yeah, so there is always this risk of third-party license and infringement. But this world is somehow moving on like this, and up till date there is no major issue, because when somebody is developing it for you and there are many other things that are coming into it, it is understood that this is the way how it is. Usually it's not a big criteria to be looked in. So don't worry. I wanted to tell you about the ownership, which can be between the person who's giving you this work and the one who is supposed to deliver. The ownership will lie with the organization who has given you that work. Keep that in mind. Yeah.